consistent with Rule 2.15 of the Nevada Code of Judicial Conduct. I will inform the Nevada State Bar about your conduct that raises a substantial question about honesty.
Honorable David A. Harding, presiding.
Thank you, Deputy. Good afternoon, and thank you, ladies and gentlemen. It's a somber moment. We all stand with solidarity and reverence for the law and our legal profession. Be seated, please. All media requests are granted, and members of the press may activate their sound and video devices. Well, if you please introduce yourselves.
Good afternoon, Marc Picker, and I'm here on behalf of Jan Tomasik and the law firm of Cozen and Connor, represented by litigation counsel Ken Kearns.
Is it Kearns?
Kearns, yes, Your Honor.
Thank you for being here.
Chris Day on behalf of Daniel Mann.
Well, Mr. Tomasik and Mr. Mann, I regret that we didn't meet under different, less public circumstances. I trust that you approached this hearing with some reluctance, as did I. This is not a metaphorical public execution. We shall get through this together with patience, dignity, and respect. I was delighted to see Mr. Picker and Mr. Day file notices of appearance. I'm aware of decisional authority that compels counsel in contempt proceedings. I carefully drafted my order. So it is not in order to show cause, thus implicating the right to counsel. As I thought about your participation, I suspected that you would offer wise advice from the trenches of Department 15, confident that you might have contributed to the pre-hearing statements and the declarations. And I invite you to patiently await an opportunity to speak. It is my intention to hear directly from Mr. Tomasik and Mr. Picker. They are counsel of record, and I want to explore the content of their opposition motion and subsequent declarations. So, thanks. I set this hearing with the hope that it could lead to a productive outcome. That's why I invited the Washoe County Bar President to be present. I thought he might consider including artificial intelligence in his presidential platform. I neither intended nor anticipated the interest that my order has generated, and I acknowledge that you must feel some discomfort. Much of what will happen today will be determined by what you say and the way you say it. I come to the bench uncertain about the outcome. I've scripted 3 different outcomes. I yearn to hear directly from you. If Mr. Kearns wishes to be heard, of course you may do so. I thought that maybe Ms. Welch would be present. I've reviewed your pre-hearing statement, the 3 declarations. You have confirmed the use of artificial intelligence, the inclusion of hallucinated citations, and your own professional carelessness. I thought I would begin by just asking you to stand and read your declarations into the record. It's 49 paragraphs of combined length. As I took the bench and saw so many behind the bar, I changed my mind. Instead, I simply asked you to each describe what you did, share what you've learned from this experience, and then present any other information you believe will be relevant. Let's begin with Mr. Mann. You're okay, Mr. Mann.
Again, I agree. I wish I could meet you in person in different circumstances. But yeah, the opposition that was filed with the initial one on May 30th, how it became drafted was May 22nd, I was assigned to draft opposition. And what I did is I reviewed the motion for summary judgment, took my notes of basically the arguments that I wanted to put out, the statement of facts I wanted to put in this opposition. And when I got all the outline that I wanted, that's when I submitted it into ChatGPT, kind of breaking down where I want the legal analysis to go, the subheadings that I wanted, and it generated an initial draft for me. From there, I was focusing on the introduction, the statement of facts, making sure to insert the exhibit citations of the exhibits we have in the case. And it wasn't until May 29th that I was focusing on looking at the citations and verifying if they were accurate, and if not, finding citations that would fit the argument that I was trying to make. Unfortunately, on that morning, the draft that was eventually filed with the court, it was the one that was the morning of June 29th. So at the end of May 29th, I created a separate file that had all those revisions. And that was an error on my part, and I willingly acknowledge that I made that mistake. To where May 30th was filed, it was not a final draft that showed all my legal analysis and review on that opposition. It wasn't until a few days later, Horseman Counsel emailed me telling me about that he noticed that there were some citation errors, which then when I looked and compared what was going on, I realized that my final draft wasn't the one that was filed. And out of haste, because I wanted to make sure the court was aware of those errors, I forego a thorough review to make sure there wasn't any other mistakes, because I knew that the first one had substantial errors, and I didn't want the court and its staff to waste their time and their resources reviewing that initial motion. And that I am regretful and very sorry that much time and energy got put into that. And I do admit and recognize that even the second one that was filed with the errata did have errors still. What I have done to try to correct this mistake, I did take 2 credits of CLE regarding AI ethics and just the use of it in our legal field and the dangers of it and being aware of it. I also, just being self-reflective of my own self, because this is a misrepresentation to the court, and I realized that I was being dishonest, and so I sought, religious leader advice, just kind of confining them, sharing them the mistakes I did, because this is a public forum, so I publicly, misrepresented my faith, and so I sought that as a way to better myself and learn from this mistake, so I can move forward. And of course, being here today to learn from you and to seek what I can do to make amends and move forward to a better counsel.
Depending on which script I choose to follow at the end, I might reference the distinction between mistakes of the heart and mistakes of the mind. And it appears to me that your culpability is greater than Mr. Tomasik's. Were you aware of Cousin O'Connor's policy about the use of artificial intelligence?
I was aware of their policy, yes.
And How do you explain your decision to violate that policy?
I just, you know, the previous firm I was with, the counsel I gave about improving my legal writing was using the use of AI. And it wasn't any training associated with that, so for me, that's when I kind of began trying to research, try to incorporate it into my writing. And ChatGPT was the one that seemed platform-wise most user-friendly using it. And with Cozen's policy, for me, when I read it, I felt like the overarching thing was it was permissible using AI generally if you're using, you know, professional responsibility, make sure you're reviewing it. And even though they were saying they didn't want ChatGPT to be used, I still use it because of it being the one I was most familiar with and already using in my writing practice.
What year did you graduate law school?
2020.
What year did AI penetrate your consciousness? When did you first learn it?
Well, implementing in my practice February of this year. Being aware of it, I mean, 3 years ago, but never an association of like putting it into practice. When AI came about, I thought it was another search engine, like Google, Bing, what have you. And it wasn't until this year where, you know, the knowledge of like, oh, this could be incorporated into legal practice, seeking, you know, a better way to write your legal arguments more persuasively or help with transitional phrases or just to give that initial formatting to help you say, okay, these are the headings I like. Now I can, you know, think more clearly how I want to insert those things.
You used the word panic in your declaration. Describe for me what happened when you first received my order, what you felt, what you did.
Oh, just dread and just thinking a bit back when opposing counsel messaged me about that error. And just that rush of emotion of, you know, this is, like I was aware of the immense mistake and just error that was to where I was presenting to the court fictitious cases that you could very well look on, rely on, and make a decision that was based on false information. And that's, you know, again, just not good candor before the court, you know, and losing that trust before the court. And getting that order, and, you know, I appreciate the length and time you put into that order. It really showed me even more the seriousness of what I did and just the reflection that I need to do as counsel, you know, just out of the case of my clients, that they deserve, you know, the utmost integrity and, you know, legal responsibility of what I am filing with the court is accurate and truthful. And
You mentioned my order, length and time. Put words to what you think your order did within Department 15. What did it cause? What do you suspect our effort and time commitment was?
to really establish precedents that any future.
No, let me ask you differently.
Okay.
What kind of time do you think we put into that?
Oh, I would even say like 100 hours plus of looking, you know, just trying to verify everything, if it was accurate or if it was not.
Thank you, Mr. Mann. Anything else before I hear from Mr. Tomasik?
Your Honor, I am very remorseful that what my actions did, just the integrity of this court and the time it took for the staff, and you know that could be put into the other things. And I'm also remorseful that the impact it gave my client, and also also just of the legal community and the trust that our clients should have in our.
My understanding is that you no longer work for Cozen O'Connor.
That's correct, Your Honor.
Is your departure from the firm related to this event?
Yes, Your Honor.
Thank you. Thomas?
Good afternoon, Your Honor.
Thank you, Mr. Picker.
I actually want to start by apologizing to the court and all the litigants involved and, quite frankly, the public. This is a serious issue. I regret deeply that didn't catch it. Regarding what I did, basically what Mr. Mann laid out, Mr. Mann and I worked together on this case. I trusted him to the opposition. On May 30th, I added some suggestions as to the factual background. I did not go through the case law. Should have. But most importantly, when it came to my attention by opposing counsel's email, I was in Philadelphia for a training event for 4 days, and that was a time at which I should have undertaken a further investigation into the matter. This is an extremely embarrassing event. It's a learning experience for me. It's a learning experience for the bar. The bright side is I'll do my best that this will never happen again under my watch on any of my cases by any attorneys in my office.
Thank you. Mr. Welch, I'm sorry.
Kearns.
Oh my gosh. I was thinking about the declaration from General Counsel.
Yes.
Mr. Kearns, I'm so sorry. Anything that you wish to add?
Just, Your Honor, I am litigation counsel to the firm. I work out of Philadelphia, as does Ms. Welch. The reason that I'm here and not Ms. Welch is that I handle all litigation the firm is involved in. I consider sanctions matters litigation. And so I made the decision that I would go. I hope you don't read anything into me for not being here. She and I both separately report directly to the chairman. And I did the investigation that sort of where we figured out what happened.
Would you add anything to what Mr. Mann and Mr. Tomasik said?
I would not, Your Honor, other than to say, obviously, the firm is, we're embarrassed about what happened. We take AI very seriously. I hope that came through with the policy. In this instance, it wasn't enough, and we're setting out to do more. Some of that is in Ms. Welch's declaration. Some of that is sort of under consideration as we speak.
Thank you for coming at such great distance. My microphone is not on. There it is. I'd prefer to continue hearing from Mr. Mann and Mr. Tomasik as to appropriate sanctions, if any, but I also don't want to disregard Mr. Picker and Mr. May. You call it, Counsel.
Your Honor, to be quite honestly, I wrote the pre-hearing statement and had Mr. Dave look at it, make some changes and sign it. That was also done in coordination with Mr. Kearns and the other members of the Cozen Court. I think what you heard is true remorse, but I want to give a little bit more maybe detail of how each of these two gentlemen have responded. And I want to make a couple of points because Your Honor made point in both the order, the possible sanction order, and the supplement of two cases. And I want to address those cases. Okay. Very briefly.
Very briefly.
The Johnson case differs from the situation in a couple of key points. And those are the points I want to concentrate on. One is it was noted that the attorney who was responsible and acted beyond recklessly, I think is how the judge put it, was still working for the firm that was in place. Cozen O'Connor has not done that. Unfortunately, this situation has led to Mr. Mann's services being terminated. Number two is that in the Johnson case, the managing partner and the supervisory attorney both kind of doubled down on, gee, we don't write these things, we should. And in that sense, that's what Mr. Tomasik is trying to tell you today, and he did very clearly in his declaration, is that when that email came from Mr. Johnson, he and Mr. Mann had a conversation. Mr. Mann attempted to get a document on file immediately. Now, one thing that was noted in those two decisions, both Saudi and Johnson, is that the lawyer in question, or the law firm in question, made no effort to correct things until they got an order from the judge. We are in a different situation. May 30th, we'll call it the hallucinatory document was filed. But on June 4th, an errata was filed with an attempt to fix it. So before your order ever came out and before they ever knew you were considering an order, they were already making it. So that's the key points there.
And the errata also contained errors.
As we noted in our pleading, in our pre-hearing statement, there's 4 errors.
Mr. Picker, I non-verbally communicated when you told me you wanted to distinguish this from the other cases. The issue before the court transcends any of the individuals who sit here. And the best defense may be a gentle defense and not a technical defense.
No, I understand that, but I just want you to understand the mechanics of logistics. There is no question. Mr. Mann has said it to you verbally and in his declaration. Mr. Tomasik said it to you verbally in his declaration of renewal, is that they own the area. They wasted this court's time. They didn't do what they were supposed to do. They didn't live up to their promise to this court as officers of the court, nor to their duty as attorneys within the state of Nevada, nor, quite frankly, within the policy guidelines that you referenced to for Codes of Conduct. And those are the things that we're at, is that, again, they're not here telling me they did anything right.
So my question then
What's that?
comes back to sanctions.
Yes, that's where I'm going. You saw in our pre-hearing statement, we suggested some possible sanctions. And it was really hard for me on behalf of Cozen and Mr. Tomasik to tell you how to punish Mr. Mann. Because of course he's already lost his livelihood. His reputation is quite tarnished. And it's not going to resurrect itself soon. No matter what you decide to do, the media is here, the media covered your order, it got a lot of interest, and that's going to follow him for a very long time. So, what we suggested, and we're going to continue to suggest also, the filing, while the use of ChatGPT, as Mr. Mann told you, was more pervasive, there has never been any evidence that it has ever been in a situation where fictitious citations were used. And in fact, once the Cozen firm received your order, Mr. Kearns had staff review every one of Mr. Mann's pleadings since April 7th, since he started working for them, and found no other errors, found no other citation errors. So this ends up being a unique experience, that doesn't lessen it, but it ends up being a unique experience. So it's not a pattern of misleading the court. There's no question that a public reprimand from this court is appropriate to both Mr. Mann and Mr. Tomasik. They wasted this court's time. They didn't do what they needed to do. Mr. Tomasik may not have signed the pleading, but his name is on the pleading. And he was the managing partner of this case. One of the remedies that is listed in both the Johnson and Maybe cases is removing the attorney from the case. That, in Mr. Mann's situation, is not going to be an issue because he's no longer going to be looking for the cause. For Mr. Tomasik, that's a little bit different, but he understands that this court may have serious concerns about his candor of the court. And should the court deem it appropriate, he is prepared, more than prepared for you to remove him from this case. We would ask that Cozen O'Connor not be removed from this case. There are other attorneys, just like there were in the Johnson case, with the Alabama Attorney General's office. There are other attorneys in Cozen's Las Vegas case that can pick this case up and continue on with it appropriately. That way, the client is not being punished, it is the attorney. Finally, we noted that referral to the state bar from Mr. Mann is almost a given with these circumstances, and that's unfortunate. Obviously, that's a good teacher. Mr. Tomasik, because of his slightly removed situation and his failure being not doing the secondary step, we believe that the public reprimand is appropriate, and him being removed from the case is appropriate. A referral to the state bar may be one step short.
Okay, thank you.
Thank you.
Mr. Day, I hope you heard my verbal cues. Mr. Picker?
I did, but I think I picked up on them. I guess one point I was trying to make is just to maybe expand a little bit on Mr. Mann, how this has affected him. You asked him some questions about what was he feeling as this was going on, the panic he felt.
My question to Mr. Picker and you is sanctions.
Yes.
So if you'll get there in a direct way, not a circuitous way.
Absolutely. So
I know you're prepared, but this may not be the right time or place.
I understand. So to directly answer your question, we agree a public reprimand is certainly appropriate. We agree that, I don't think it's a moot point that removal from the case, this action is appropriate. Now, I understand it's a moot point because he's been terminated from this firm. I think it still sends a message and sets a precedent that if you engage in this behavior, you're subject to removal from a case. It should not be lost in the court that he has been terminated as a direct result of his mistakes here. And we understand that referral to the state bar that's not something where he's incredibly worried about that, but that's inevitable here. And the unknown of what will happen to the state bar is weighing incredibly heavily on him. Those are the three sanctions that I would ask for, and a closing point I would just make to your honor is that the impact on this man, this is not lost on him, how serious this is. Losing his job, this is not no big deal event for him. He is the sole provider for his household. He has 5 children. He let himself down when he did this. He let his family down. He let the state bar down. The nervousness he had coming here is, I don't normally see that with my clients do, but clients who have are facing much more severe punishments than they're coming into this court, and he is, the effect on him has been enormous, and could not be more contrite and apologetic, and just wants the chance to still engage in the practice of law moving forward. And I don't think it should be lost in the court of media attention. Already mentioned it, losing his job. He's seeking employment right now, and he has not been successful yet. And I think that's going to stick with him for a long time. And so I don't think the sanctions I'm asking for are nothing when you take into account the human factor of who Mr. Mann is, the situation he's in. I could go on and on with the person he is. I don't know if the court wants to hear all that, but this is impacting him. He takes it incredibly seriously. And I think those sanctions send a message to the bar. And I mean, this is the worst day of his career, not something he's ever going to forget. If you have any other questions, I'm happy to answer them, but if not, I'll
Thank you. Well done, Mr. Daniel. I don't want to leave the bench. It's late on a Friday afternoon. I just want to think for a moment and kind of review my notes. Council, you can imagine that I spent some time thinking and preparing for today's hearing. I have a general script of things that I want to say, and I could have gone into one of 3 different directions. You can imagine one is most severe, one is moderately severe, and one is creative and probably unpredictable. I didn't invite this, and I don't enjoy it. But I have a sense that what I'm about to do and what you have experienced is much larger than any of us. I care more about what occurs systemically after today. Courts across the country are wrestling with this very issue. The unethical use of artificial intelligence. Decisions are being issued rapidly, almost on a weekly basis. Just Tuesday of this week, September 2nd, the United States District Court for the Southern District of Indiana, in a case entitled Davis versus Marion County Superior Court, issued yet another sanction order for the unethical use of generative AI. There, and the reason why I didn't want Mr. Picker to go too far into distinguishing facts, there, an attorney filed a motion containing only 2 AI-generated hallucinated citations. And the court's decision from 3 days ago is instructive. It wrote, and I quote, "There is nothing fundamentally improper in the use of AI tools to draft a brief. Rather, it is counsel's abdication of his responsibility to ensure the information he provided to the court was accurate." Close quote. A few more excerpts from Davis. Remember, September 2nd, 3 days ago. A few more excerpts emphasize the point. Each is a quotation. Courts have consistently held for decades that failing to check the treatment and soundness, let alone the existence of a cited case, warrants sanctions. Next. Confirming that a case is good law is a basic routine matter and something that is expected from every practicing attorney. Next. The fact that counsel did not file the brief with the intention of deceiving the court does not excuse his failure to check the citations. Next. Whether a case cited is obtained from a law review article, a horn book, or through independent legal research, the duty to ensure that any case cited to a court is good law and is nearly as old as the practice of law. The Davis Court imposed significant sanctions, 2 hallucinated citations. It wrote in footnote 5, the fact that there are so many occurrences in such a short period of time, even after multiple orders issuing sanctions in other cases have received such a great deal of attention, this underscores the need for the continued imposition of sanctions to attempt to deter such behavior in the future. I suspect there might be another case published, or decision published next week, and the following week, and so on, until the profession itself can align with this growing technology. That's my main objective today. Not to shame, not to punish gratuitously, but to help our profession progress into compatibility with this technology. My review of these judicial responses to generative AI and hallucinated citations reveals some inconsistencies in the remedy. But a consistent theme does emerge. I paraphrase it to illustrate. That theme is that generative artificial intelligence, untethered from human intelligence, is an existential threat to our legal profession, to the work of the judiciary, to the rule of law, and to the great legacy of justice that we have inherited. It may seem hyperbolic, but the sanctity of precedent and stare decisis are the predicates for our entire system of justice. That's why we're here today. It's not about the individual, Mr. Tomasik or Mr. Mann. Today, you're at the tip of the spear, but it's larger than that. Now to decide which avenue I will go to. The Justice of the United States Supreme Court is on a book tour today. And I read a news account of the speech that she gave just during the lunch hour. And she spoke to humanizing the law through the acts of the judges. And I've just decided how I'm going to respond, and I moved in large measure, forgive the personal reference in such a public setting. But I'm really moved by Mr. McGrath as he entered the room. Half of you will be partially satisfied with my work, and half of you will be partially dissatisfied with my work, and you'll jump over that fence of satisfaction and dissatisfaction. I don't mean to highlight Mr. McGrath for any work that he's done in the court. He will assure you that I both ruled for and against him. But there is no lawyer I know who reveres the courtroom greater than Mr. McGrath. He reminds me of that every time he enters this historic courtroom. He just completed a 5 or 6 week bench trial in this courtroom, and happily, with a smile, announced it was his last trial in this courtroom. And as I saw Mr. McGrath enter the courtroom, and I looked over the bar, and considered what you've written and how you've spoken. I'm going to take the creative, unpredictable approach. My August 6th order simply asked the question. It was a form of charging you with my suspicions. Suspicions that you fell below the standard you accepted when you swore your oath as officers of the court. And today is a form of trial, and the evidence has been presented, and your conduct is now known. Again, you fell below the standard of professionalism. You swore an oath to uphold. I've chosen the creative, unpredictable outcome not to dilute my serious concerns, because I think it reflects the greatest possibility of system improvement and redemption. So I focus on my response, a form of punishment. I will impose sanctions, sanctions short of contempt. And after I announce my sanctions, I will suspend execution of those sanctions. With a hope for this systemic, constructive outcome. Mr. Tomasik is removed as counsel from the case. And if Mr. Mann was still employed by Cozen O'Connor, he also would be removed as counsel from this case. Mr. Mann and Mr. Tomasik shall each pay a $2,500 fine. Mr. Mann shall pay his fine to the Legal Aid Center of Southern Nevada. Mr. Tomasik shall pay his fine to the Northern Nevada Legal Aid Organization. Consistent with Rule 2.15 of the Nevada Code of Judicial Conduct, I will inform the Nevada State Bar about your conduct that raises a substantial question about honesty, trustworthiness, and fitness. And I suspend execution of those sanctions in lieu of conditions that you may choose to accept. Now is when the work of a judge becomes complicated. The challenge to having authority is knowing how to wisely use it and not use it. It's the work of our careers. It's an imperfect art. I think of Judge Breen, who sat at this bench for close to 30 years, who had a sign over his doorway that said, "Judge like a champ today." It is an aspirational standard that we are always reaching for and rarely touching. I'm required to act without fear of criticism, and my decision may warrant criticism, which I accept. My primary lens is as a judge charged under the code with promoting public confidence in the independence and integrity of the judiciary. That is my prime directive. And today, in our modern era, our legal profession, the judiciary, have become topics in local and national conversations, politicized conversations. It is difficult to, it is an inviting challenge to promote public confidence in the judiciary. We can do without self-inflicted wounds, which you have created. Our profession is better than that and needs more from you. That's my lens. But I've also thought about your lens. In fact, I'm reading your body language as I speak, peering into your eyes, and I have a sense for what you are experiencing. This is but a moment in your careers. None of us are binary. We each, everybody in this room, acts in ways that warrant emulation and condemnation. Each of us have made mistakes. For some of us, fortuitously, our mistakes remain concealed and unknown to others. I will speak to this concept of distinguishing between mistakes of the mind and mistakes of the heart. I first read that phrase a long time ago, probably 20 years ago. J. Neely Johnson was president of the Second Constitutional Convention in July of 1863. He had been governor of the state of California before moving to the Nevada Territory. He would soon be appointed as a justice of the Nevada Supreme Court shortly after statehood. In his opening remarks to convention delegates, he said, quote, "I beg of you to extend to me all possible courtesy while occupying this chair. If inadvertently I should make errors of ruling, I trust that you will impute them more to the head than to the heart." And this distinction between mistakes of the heart and mistakes of the mind is critical for me to understand the remedy. The former, mistakes of the mind, occur often in the human dynamic. They're easy to understand and easy to forgive. Mistakes of the heart are malevolent. They're dangerous. And they are worthy of swift, certain sanction. And I'm still thinking about Mr. Mann's mistake of the mind versus mistake of the heart. I think that Mr. Tomasik's mistake was carelessness, delegation of unearned trust. So I'm seeing the two of you slightly different. But I wonder what more could be done, or should be done to both of you that hasn't already arrived in your lives. I was impressed by Cozen O'Connor's commitment to professionalism. I was heartened when I read Ms. Welch's declaration. Your firm established structure long before this event to avoid the very type of misconduct that is before you. And this event has already reverberated for our legal community. So what more could be done, should be done? What I really want is for this event to be a chapter, a case study for your personal improvement, but more important, for systems improvement as we welcome artificial intelligence as an additional tool in the lawyer's tool belt. Actions do compel consequences, but consequences arrive in different forms. I'm beginning to regret the length of my script. I don't enjoy this. And it's larger than any of us. I attended a criminological theory course a long time ago at the Judicial College. And a textbook popped into my mind this week. I hadn't thought about it in a very, very long time. The concept is presented by a criminology professor named John Braithwaite. I went to that textbook yesterday, and I reread his entire essay. It's entitled Crime, Shame, and Reintegration. It is the antithesis of public execution. Ironically, I went to AI after I read the essay in its entirety, and I asked it to confirm what I thought I had learned. Professor Braithwaite is an advocate for restorative justice. Restorative justice. He refers to this as reintegrative shaming. He posits that reintegrative shaming can be effective to reduce crime and recidivism. Its components, 4 parts. I'm nearly to the end of my script. 4 parts. 1, to distinguish the individual from the act, holding space for the idea that we are rarely as bad as the worst things we do. 2, it's important to communicate shame within a larger context of respect. That may inspire remorse and a resolve to do better. Gratuitously adding stigma, labels, and outcasting can be counterproductive. 3, reintegrative shaming is most effective within communities that have strong social bonds and interdependency. And our legal profession has strong social bonds and many features of their interdependency, whether it be partners, associates, colleagues, bar associations, law firms, opposing counsel, even clients. We interact with each other. We're accountable to each other. And then 4th and finally, forgiveness is embedded in reintegrative shaming, sometimes even with ceremony, to allow the shamed to rejoin the community. Following the theory of reintegrative shaming, Mr. Mann and Mr. Tomasik may choose to avoid their sanctions by doing the following within 60 days of my written order. They shall each send a letter to the Nevada State Bar President and Vice President, informing them of their use of generative AI. I know your letter, if you choose to follow this condition, will be written differently because of your different participation. You shall each send that letter, include a copy of my August 6th order and the 3 declarations in this case. The purpose of sending this letter to the bar president and vice president is not for me to initiate disciplinary proceedings, but instead, you should offer to make yourselves available as a resource, as a mentor, for assignment to an appropriate committee that analyzes AI practice rules, volunteering to speak at a continuing education, maybe even writing an article for the Nevada Lawyer or other bar publication, something along the themes of mistakes made and lessons learned. Second, you will each send a letter to the deans of your respective law schools. It will be a shameful moment should you choose this condition, informing them of your use and participation or tacit carelessness should you choose to send a letter to the deans of your law school. You will include copy of my August 6th order and the 3 declarations. And you shall offer to be guest lecturers at an ethics course or other course focusing on rules of professional conduct or generative artificial intelligence. If your respective deans and ethics professors choose to invite you as guest lecturers, I would be proud to join you on a panel to share my perspective as a judge. It would also be appropriate to invite opposing counsel for their perspective in reading, cite checking, and struggling with the fugitive law that you cited. Now, other than a potential Zoom call with a law school ethics class, I will not have any interaction with you, Mr. Tomasik, or you, Mr. Mann, until the underlying dispute is resolved. But I look forward to a time when you've opened the next chapter in your careers, when I can share a private, kind word and shake your hands. I respect the way that you responded to my question, and I respect your potential as lawyers and leaders of our profession. Seeing so many members of the bar behind the bar, reminds me of the sustenance and affirmation, the goodwill that exists among members of our profession. So I end with a reference to the late Co. Sloan. Attorney, who likely appeared in this room countless times. Member of the Nevada Assembly and Senate. I can't recall anything Mr. Swope did as a lawyer. I can't recall anything he did as a legislator. But the memory of Mr. Swope penetrates my soul deeply because of what he did do as he led the organization Lawyers Concerned for Lawyers. He embodied what it meant to be a member of the Nevada bar. I and others behind the bar have received the sustenance and affirmations. When the swords are sheathed, when the battles end, there's a fellowship among lawyers. It's valuable. It's priceless. So there may be some in this room who grieve what you have endured publicly. I welcome and invite them to introduce themselves, to share a kind word, and to shake your hands. I shall stand in recess subject to my written order. Good day.
All rise.